Next, I'd like to turn to Luca Bertuzzi. So, as I said at the beginning, Luca, you have followed the gestation and birth of the AI Act as a journalist. So, what are your reflections?
Thank you, Robert, and thank you to AI4People for inviting me to join such an interesting discussion. Well, I mean, when we are talking about compliance, of course, we can talk about this from several angles. We just heard from the Commission about the AI office. Of course, it will take time for the Commission to get this up and running. They will be competing with private companies to get AI experts and so on. From the Commission side, what we are seeing also with other digital legislation is that they will probably have their hands full with compliance with the legal deadlines. So we have the Code of Conduct for Foundation Models. There will need to be guidance on the bans on Article 6 for high-risk categorization. And, you know, the AI Act has included certain mechanism to make sure that the Commission keeps up with technological and market developments. And this is the real challenge of the AI regulation, because AI is a moving target. And the risk is that the Commission is so overwhelmed, at least at the beginning, to keep up with the legal requirements, that it loses touch with how the market is going, how the technology is moving, and basically does this consultation with the stakeholder forum and the scientific panel just as a tick-the-box exercise, and doesn't really receive ideas from academia and from those that are involved in developing this technology. At the national level, national regulators are often underestimated, but they will also play an important role. And what's important to note is that they will all be different authorities. There will be cybersecurity agencies, telecom regulators, DPAs, and so on. And if we look at the data protection field, for example, it's taking years to develop a shared doctrine, a shared understanding of the key principles to issue guidance. And there was data protection law before the GDPR. So imagine now with AI as a new regulatory field, with authorities that come from completely different background, it's going to take really a long time to develop a shared understanding of the key concepts that, of course, will also be litigated. So we will also need case law to define how the AI Act will be applied in practice. And then there is compliance from the private sector. And there I'm not so much thinking about, you know, AI providers, but more about the users and the deployers. When I talk to in-house lawyers, especially data protection officers, they are being told, you're the AI expert now, so you have to tell us if we fall into the high-risk category or not. And there is a lot of confusion there. I think Article 6 is probably not the best drafted part of the text. And, you know, that's also why external experts and B2B services will be quite key in the private sector to determine how companies will comply with the AI Act. So we also talked about international alignment and the AI Act as potentially an international benchmark. I think, you know, there is definitely potential for that. We are seeing countries like Canada, US states like Colorado following similar footprints as the EU in this direction. But what I would stress at this point is that how the Commission and the regulators will keep up with the market will also determine whether other jurisdictions will look at the AI Act as a success stories, and whether they will decide to follow the European model in this case. So, you know, what is really the relationship between the EU AI Act as an international benchmark and the capacity of regulators to make it future-proof and for compliance to be reasonable and brought down at the level with companies. These are all interrelated and should be looked at as a single issue. So I'll stop that for now.